People are regularly arrested and sued, and in many cases, the defendants lack the ability to get a lawyer due to his or her financial status, especially in a country like Nigeria where the poverty rate is high, thereby making it hard for many persons to pay their legal fees. The state, therefore, is mandated by law to provide lawyers for such persons, but there is still doubt among citizens on how well the lawyers provided by the state can represent the defendant, especially in situations where the defendant seems to be guilty. This leads to our discussion today, but first, I want to welcome you to Wheel of Justice. It is a legal program that aims to help you better understand the administration of criminal justice law. It is brought to you by the Abia State Administration of Criminal Justice Monitoring Committee, Prisoners Rehabilitation and Welfare Action Power, with the support of the Open Society Initiative for West Africa, OSIWA, and Abia State Justice Reform Team. My name is Ifeanyi Awa, and this program comes your way on Tuesdays 3:30 p.m. on Flow 94.9 FM. Moving on, our topic today is the duties of a legal practitioner engaged for defendants under the administration of Criminal Justice Law 2017. But first, I will take a quick break, and when I come back, I will introduce my guest this afternoon as we dissect this issue. Stay tuned. Yes, this is still Wheel of Justice, and quickly let me move on to my guest this afternoon. I was speaking with Nnamdi Eluwa Esquire, who is the immediate past chairman, Nigerian Bar Association Umuahia branch, and also member of the Abia State Administration of Criminal Justice Monitoring Committee. Welcome to our studios.
Thank you.
Also, just as last week, I had Kelechi Imo right here, who is the Associate Program Officer, Prawa Abia State, who is also going to be an observer today. Welcome to the studio again.
It's always a pleasure, bro.
All right, so let's dive into the issue at hand. We're talking about the duties of a legal practitioner engaged for defendants under the administration of criminal justice law. Sir, I'm going to have to start with a simple one. Let's better understand the law that requires a state to provide the defendant with a legal practitioner.
When you have a situation where a defendant, as called now by the Administration of Criminal Justice Law number 12 of 2017, prior to that we call them the accused person.
Okay.
But now the law recognizes them as defendants. Now, if there's a defendant in a matter or in a case involving capital offenses or in any criminal matter at all, it is required that they must be represented by a legal practitioner.
Okay.
Yes, and then if they don't have any or cannot afford one, the courts, so moto, that's on their own, can either mandate what they call the legal aid council to provide one for them, or most times, on a very light note, can call the Nigerian Bar Association to also work in, for them.
All right.
Yes.
Okay. Now we know the state provides this legal practitioner for the defendant. Just to make things clearer, does this defendant have to pay any legal fee?
Most times you don't pay any legal fee.
Most times
you don't pay any legal fee, especially if he's coming from the legal aid council.
Okay.
Yeah, it's a free service, legal service.
Legal aid council. Let's understand what that is.
Yes.
For those who are hearing the word legal aid council,
yes.
What is it? An organization?
Yeah, legal aid council is an offshoot of the Ministry of Justice. Federal Ministry of Justice, and then their issue is to provide free or pro bono services to defendants.
All right.
Oh yes.
Okay. Now, say sometimes you have to pay, and most times the defendant doesn't have to pay. Means there are occasions where the defendant might have to pay.
Yeah, when I said most times, I use the word most times on the platform that legal fees are not paid per se when you're dealing with the legal aid counsel.
Okay.
Unlike when you're dealing with a private practitioner who will go through his charge list and tell you how much you're supposed to pay before he will, he'll come to court to defend the defendant.
Okay.
Oh yes.
All right. Now let's move on to the next question, where I want to ask: are the best lawyers provided by the state? Because a lot of persons believe, if the state provides this, might not be the best hands. So are the best lawyers the ones who are provided by the state, or maybe just beginners?
Now, there's something that this legal aid counsel does most times. There are private lawyers who also register with legal aid counsel.
Okay.
And when they are registered with legal aid counsel part time, like my office is also registered with legal aid counsel.
Okay.
So most times they push matters to us to handle, and then we'll do that. And then most times the legal aid counsel pays some patronage sum to the office for that. But we'll do that professionally, for the defendant without charging fees, any type of fees from the defendant.
So that means that the lawyers or the legal practitioners provided by the state are usually the best hands.
Of course, most times.
All right. Before I go to the next question, for those who are just tuning in, this is Will of Justice, and I've been speaking with Nnamdi Eluwa Esquire. He's the immediate past chairman, Nigerian Bar Association, Umaya branch, and also a member of the Abia State Administration of Criminal Justice Monitoring Committee. We're talking about the duties of a legal practitioner engaged for defendants under the administration of Criminal Justice Law 2017. And that will take me to the major issue we have for today. What are the duties of the legal practitioner who has been engaged for this purpose?
Well, under the Administration of Criminal Justice Law number 12, 2017, there are some areas which actually dealt with the defense lawyer. When I mean the defense lawyer, a lawyer that's engaged for the defendant in any criminal proceedings. Now, if you look at section 17 of the said law, it talked about when a suspect, of course, before he graduates to be the defendant, a law court is taking statement before the police. Now, the new law states that a legal practitioner of the suspect's choice can also be present while the suspect is making his statement.
All right.
Now, this is to avoid what we call trial within trial. When the matter goes to court and a party, especially the defendant, will always raise an issue that the voluntary confessional statement of the defendant was not taken, or was done under duress or under an influence. So when the lawyer is there and the man is making the statement, it actually eradicates the process or the procedure we usually have before now, what we call trial within trial. That's the issue. And then secondly, we also have the procedure in law, which we also call what we call the plea bargain. If you look at the plea bargain, that is actually where that same law actually brought to bear the work or the duties of a defense counsel. Now, if you look at that section 267 of the law, it talked about the plea bargain. The plea bargain comes where someone has multiple offenses, or number of charges, facing in the court, and then the prosecution looks at it, or the defense looks at it. Instead of going the whole hurdle of the trial, let's try and agree that maybe there are 5 count charges. Then you can agree to the list. Now, those are the issues that it's like an agreement that must be entered by the prosecution and the defense.
Okay.
Now, but with the consent of the victim. Let's talk about the issue of rape or issue of armed robbery or whatnot. The victim, who is the nominal complainant, must give his consent to that. Now, in that regard, before an agreement will be reached on that, the defense counsel must be in agreement with the prosecution and, of course, with the defendant for such issues to take place.
That's the plea bargain.
The plea bargaining.
All right.
That's what I'm talking about. So that's where also you have the defense counsel play a very big role. But if you also look at it down there, you find that there are so many other laws. But one I'm going to talk about the one that what they call the practice direction issued by the Chief Judge of Abia State, Honorable Justice Onoha A.K. Owe, on the 3rd day of June 2020. And in that practice direction, he actually brought to bear or brought in full measure the duties of the defense counsel. With a permission, I can also read. If you look at
go on.
Okay, yes.
Yeah, go on.
Yes. Now he talked about where, especially, he centered his practice direction one on the duties of the defendant lawyer or the defense lawyer, and then talked about the conduct through trial. Now he talked about the duties as to include the admissibility of confessional statements, the one I talked about, especially in section 17 of the law. He emphasized more on that and elaborated more on that, on what the defense counsel should do. You know, if you look at that section 3.1 of that, it says where a defense is desirous of objecting to the admissibility of confessional statements, what the defense lawyer will do is also stated there. If you look at the section 2, subsection 2 of that, it's also stated what the defense lawyer must comply with in order to get subsection 1 done.
Okay.
Yes, if you also look at subsection 3, it's also talked about the process you have to do as a defense lawyer to make sure that those things are complied with. And
right.
in the law, yes.
Okay, now let me come in here. We're talking about the plea bargain, and the angle where I want to come in from is a part where the prosecutor has to reel out the sentences to the defendant, and the defendant is aware of, okay, this is what I might have to go through if I keep dragging this case on. And then instead of going through, just like I just explained, instead of going through all these hurdles, we could just have an agreement and then call this stuff. Means that I have to agree that I am guilty here, instead of dragging this case on, where I might probably be found not guilty or guilty at the end. But instead of going through all these hurdles, I just have to say, you know what, I'm guilty right here. Let's make the sentences shorter. That's what you're saying.
Yes, that's actually what the
plea bargain is all about.
The plea bargain is all about, as incorporated in the law.
All right. Now I'm going to go to the next one, where we're going to look at from both sides. You know, both the part where the state provides a legal practitioner for the defendant, and where the defendant also gets his or her own legal practitioner to represent him or her. Now, in a case where the defendant seems to be guilty, that is, the legal practitioner knows that this defendant is guilty at this point. How should this legal practitioner act towards the defendant?
In line with plea bargain?
No, not in plea bargain. No more sentence. Like, sometimes you have a situation where the defendant is guilty of the offense, but is saying not guilty in court. But the lawyer in charge, the lawyer defending that defendant knows that he is guilty. Does the lawyer go back to court acting like his client is guilty or not guilty?
No, naturally you can't tell. The lawyer will not tell the defendant, except maybe this issue of plea bargain
comes up.
You know, where the defendant can now opt. See, I think I have done this. Why don't we do it this way? The lawyer can also advise the defendant in private on that. You know, as the matter proceeds, can tell the defendant, see, why don't you do it this way? Why don't you do it this way? Because if we go through this hurdle, look at this, we can have one or two issues there, and then if care is not taken, you might have the maximum sentencing as against the minimal sentencing, you know, to the maximum sentencing. But that aside, when a lawyer is defending a suspect or a defendant, as the law provided, the lawyer has to do that to the best of his ability and to the best of his knowledge and what he can actually do. He has to work according to the rules. There are rules of professionalism, especially when you are handling cases for the defendants. You don't go outside the rules. You do what you're supposed to do, and then you leave the rest.
All right.
Yes.
Okay, this is still Wheel of Justice. We'll have to take a quick break. When we come back, I'll open up the phone line so you can also call in and ask your questions. Numbers to call are 0808 182 6949 or 0811 605 2949. We're talking about the duties of a legal practitioner engaged for defendants under the administration of criminal justice law, and I have been speaking with Nnamdi Elua Esquire, who is the immediate past chairman of Nigerian Bar Association Umuahia branch and also a member of the Abia State Administration of Criminal Justice Monitoring Committee. When I come back, I'll open the phone lines so you can ask your question. Stay tuned. This is still Wheel of Justice. My name is Ifeanyi Awa. Just as you know, we're talking about the duties of a legal practitioner engaged for defendants under the administration of Criminal Justice Law 2017. And I was speaking with Nnamdi Elua Esquire, and he has been explaining the laws guiding this and also the duties of a legal practitioner in this scenario. But we also would love to get your own thoughts on this, your questions. Numbers to call are 0808 182 6949 or 0811 605 2949. Hello?
Hello?
Hello, good afternoon. What's your name?
Good afternoon. How are you?
I'm okay. What's your name and where are you calling from?
Yes, the person calling you is Henry Enyofu. I'm calling from Umogele and Sega in Isialangwa North.
All right. Henry, go on with your question, please.
Yes, I want to thank the resource person there, Nnamdi Elua. He has been very, very explicit in his explanation.
All right.
My question is this. How long does it take a defendant lawyer how long does it take for a defendant lawyer to spend in carrying out the defense? Well, I am not a lawyer, just an explanation to this. And joined to this is that sometimes lawyers continue to spend time romancing cases so that people will come, the defendant, the accused person or whatever, will be spending money on fuel and all this and that. A case that is supposed to finish up in 6 months will last for more than 1 year or 2 years.
All right.
What is the maximum period an accused person should be looking at on an average case?
All right.
That's my question.
Thank you very much, Henry. You want to answer that?
Well, it depends on the case, and the charges also, contain in the said matter. But one of the things that the law, what we're talking about, the Administration of Criminal Justice Law number 12, 2017, came to do and to reform is to speedy justice. That's just the issue. And then you look at, before now, we don't have, we have what they call the CPA, where there are so many procedures and so many issues that one, had to go through before getting things done. But if you look at this one, the time this matter is in the police, there are times allocated for the police, the capital offense, to forward them to the office of the DPP, and then for the DPP to bring the matter before the appropriate court for prosecution. And then there's what you also call the front loading, where the case files that's received by the DPP will also be made available. A copy of the case file will also be made available to the defendant counsel, for him to be properly guided as to know the number of witnesses the prosecution is going to call. And you find out that everything is just working out speedily. That's why we talked about this issue of the plea bargain that's also there. The essence of plea bargain is also to stop or to shorten or to make sure that the time the court will spend in handling some of these criminal matters will be drastically reduced. That's actually the essence of plea bargain. and much more. So I will not come here now and tell you how long it's going to take, but one of the things I know very, very well, that this law that is in vogue now has actually reduced the length of time in prosecution of criminal justice, especially in Abia State, to the barest minimum. That's the truth.
All right, we'll take more calls right now. 0808-182-6949 or 0811-605-29 or 49. Ask your questions pertaining to the duties of a legal practitioner engaged for defendants on administration of criminal justice law. Hello, good afternoon. Hello, good afternoon.
Good afternoon, please.
Good afternoon. What's your name?
I'm speaker with it. My name is Joseph Wang. I'm calling from Bauchi.
All right.
I want to ask the lawyer there, how do one access these legal aid services? That's my question.
How does one access the legal aid service, right?
Yes.
All right. Okay.
Yeah, the legal aid services is just there. We have it in all the states of the Federation. With the headquarters at Abuja, but in Abia State here we have them at number 27 School Road, Omahia. So you can easily walk in there and then they'll be of help to you.
All right. So keep the calls coming in. I don't know if we have enough time to take more calls. But before we do round off, there's actually a particular question I'd love to ask right now about when the state provides a legal practitioner for a defendant. Does the client or the defender have the right to reject that legal practitioner and ask the state to provide another one?
Well, the law is straight law that every defendant has the rights of the lawyer of his choice.
You know, there's a part of the law that states that after, if the defendant doesn't like the legal practitioner given to him, he can provide his or her own. And after 30 days, if he can provide, then another one has to be given. He has to have another one.
Yes, if that's what I'm saying. In essence, that's what I'm saying. The defendant has the right to reject if he's not comfortable with the legal practitioner that is sent to him, either from the Legal Aid Council or any legal practitioner that is out there on pro bono basis.
All right.
Yes.
I think we'll take one more call before we round off. Hello.
Hello.
Hello. Good afternoon. What's your name?
Good afternoon. Can you hear me?
We can hear you loud and clear. What's your name and where are you calling from?
I'm calling from Iguana.
Okay, go on.
Yeah. Yeah, please, you said they have office at the 27 schools. And is it possible for one to have their phone number so that one can be able to know the days they operate?
All right. Is it possible to have the phone numbers?
Well, I'm not. I don't work with legal aid counsel. I'm a private practitioner. But if you walk into that office, you see them.
All right.
Yes, they are there, 24 hours, Monday to dawn. Yeah.
All right. Thank you very much for coming through. I've been speaking with Nnamdi Eluwa Esquire, who's the immediate past chairman, Nigerian Bar Association, Umuahia branch, and also a member of the Abia State Administration of Criminal Justice Monitoring Committee. And we've been talking about the duties of a legal practitioner engaged for defendants or the administration of criminal justice law 2017. Thank you very much for coming to our studio. Hope you'll be back here very soon.
Thank you so much.
All right. Also, Kelechi Imo, thank you very much for being a good observer today. Don't forget, Wheel of Justice comes your way Tuesdays by 3:30 p.m. It is brought to you by the Abia State Administration of Criminal Justice Monitoring Committee, Prisoners Rehabilitation and Welfare Action Power, with the support of the Open Society Initiative for West Africa, OSIWA, and Abia State Justice Reform Team. It's been an honor having this program today. My name is Ifeanyi Awa. Till next week, do have a great week ahead. Bye.